Okay, let's unpack this immediately. You want the absolute high-retention shortcut to understanding the single most important, most condensed statement of intent in Indian governance.
The preamble of the Constitution.
Exactly. This isn't just an introduction. It's what's universally acknowledged as the soul and the identity card of the entire document.
It's the enduring vision document, and that's precisely why we're dedicating this deep dive to a word-by-word structural analysis. It was adopted and enacted, by the Constituent Assembly on November 26, 1949.
Right.
And it sets the fundamental philosophical and political moorings for the Republic. But for the serious learner, the one preparing for these high-stakes examinations, the central tension lies in understanding why.
Why this single paragraph was so fiercely litigated.
Precisely. Why it went to the Supreme Court, and how its precise wording dictates the interpretation of everything that follows, from fundamental rights all the way to federal structure.
Welcome, everyone, to the Deep Dive. If you are here, it's because you value deep, structured, rapid knowledge acquisition that, cuts through the noise.
Especially when tailored for the rigorous demands of thorough learning.
Yes, perhaps in the context of civil services preparation or just, profound intellectual curiosity. Your willingness to master these foundational texts is what separates a superficial understanding from genuine expertise.
It really is.
And we must pause right at the beginning for a crucial and heartfelt moment. A massive, sincere shout out to all our existing members, our legend YouTube members.
Absolutely.
Your consistent support is the sine qua non for us creating content at this level of quality and detail. This research takes extensive time, and your membership is what sustains this entire effort. We offer our deepest gratitude.
We really do. Thank you for enabling this necessary level of conceptual clarity.
And to everyone listening, if you find this material useful, and if you're in a position to, please consider subscribing and joining our paid membership on the YouTube channel. It directly supports the continuation of these high-effort deep dives.
That makes a huge difference.
Also, please take a moment to like this video and share a valuable comment below about the one insight that stands out to you today. Your engagement helps this essential knowledge reach the people who need it most.
Now let's define our mission for today.
Our mission today is surgical. We are using the authoritative framework derived from M. Laxmikanth's Indian Polity, Chapter 5, along with the required context for high-level exam preparation.
Right.
Our goal is not just recitation, but robust analysis. To unpack the precise meaning and constitutional weight of every single term in the preamble, ensuring you have the conceptual foundation that underpins all subsequent constitutional study.
Think of it this way. When you approach complex Manswer's questions, whether on judicial review or the implementation of land reforms, or even the efficacy of social justice schemes, your argument has to be grounded in these preamble concepts.
Justice, sovereignty, democracy.
Exactly. The preamble is the ultimate lodestar. Master this one paragraph, and you truly own the foundation of the polity syllabus.
So let's begin with the text itself, the resolution the founders gave themselves. I'm going to read the full text of the preamble as it was ultimately amended in 1976, which is the version we use today.
Okay.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution.
That opening declaration, we, the people of India, it is not merely a formality. It is arguably the most powerful clause in the entire Constitution.
It establishes the sorts of authority, right?
It is the definitive statement that political sovereignty vests not in a monarch, not in an external power, and not even in the Constituent Assembly itself. It vests exclusively with the people of India.
So it's an assertion of self-rule and deliberation from the very first word. By explicitly naming the people as the source, they reinforce the purely democratic and republican nature of the polity.
They did, right from the outset. It contrasts sharply with systems born from, say, external declarations or some kind of inherited power structure.
This is critical to remember then. When the Constitution refers to itself being given to the people, it's a statement of popular sovereignty.
Yes, distinguishing it from constitutional systems that might trace their origins to declarations by monarchs or, treaties between states.
And focusing on the very end of the resolution, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. We have to clarify this date. It's a common stumbling block.
Absolutely, a very common one. November 26, 1949 is the date the Constituent Assembly formally adopted the Constitution.
Okay, adopted.
It's the date of self-enactment of the document as a foundational legal text. This must be kept separate from January 26, 1950.
Which is the date of commencement.
Exactly. That's when the majority of the provisions came into legal force and India formally became a republic.
Yeah.
The preamble speaks directly to the former date, marking the resolution of the people themselves.
All right, now we move to the 5 fundamental ideals that define the nature of the Indian state. Sovereign, socialist, secular, democratic, republic. Let's start with sovereign. What does the term imply, both internally and externally?
Well, sovereignty fundamentally means supreme and unrestrained authority. So internally, it means India is independent of any domestic, feudal, religious, or, external colonial power.
And externally?
Externally, it signifies that India is free to conduct its international relations, to join or leave any international body like the Commonwealth or the UN, and to manage its affairs without any external interference. It is neither a dependency nor a dominion.
I want to probe the implication of this sovereignty, specifically regarding territory. If the Constitution is given by the people, how does sovereignty allow the government to acquire or cede territory without an explicit vote from the people?
That's a powerful challenge, and a very important one. The implication of sovereignty is that the state possesses complete legal personality. As established by the Constitution, the power to legislate, including over territorial integrity, rests with the parliament.
Okay.
Therefore, as a sovereign entity, India can acquire foreign territory, which is a standard exercise of state power, or, crucially, cede a part of its territory to a foreign state.
Which it did, for example, in the context of the Beru-Bari Union.
Exactly. The Supreme Court in that context later confirmed that while ceding territory required a constitutional amendment under Article 368 due to the nature of the land transfer, the power to perform that act was an inherent component of external sovereignty.
So the preamble confirms the source of this power, the people, but the mechanism lies in the enacted law.
Precisely.
Next, we dive into socialist, a concept already implicit in the directive principles of state policy, but added formally by the contentious 42nd Amendment in 1976. This is a crucial area for any in-depth study.
Indeed. It's vital to stress that the directive principles of state policy, or DPSPs, which are found in Part 4 of the Constitution, already envisioned a welfare state.
They already aimed at socioeconomic democracy.
Right. And these principles are, importantly, non-justiciable, meaning you can't go to court to enforce them, but they are considered fundamental to the governance of the country. The addition of socialist explicitly reinforced this commitment.
So what brand of socialism does India embrace, and how has it evolved over time?
India adopts what is known as democratic socialism. This is a complex ideology that holds faith in a mixed economy, where both the public and private sectors coexist.
But with a specific goal.
Yes, an explicit aim to eradicate poverty, disease, and inequality of opportunity. It is not the centralized command economy state socialism often associated with communist states.
And the judiciary confirmed this interpretation.
It did, quite early on. In the landmark D.S. Nakara versus Union of India case in 1983, the Supreme Court interpreted the term socialist in the preamble to mean working towards securing a decent standard of life for the working class and assuring socioeconomic justice.
But how does this preamble ideal reconcile with the massive economic liberalization that began in 1991? Doesn't liberalization, which emphasizes the free market, potentially contradict the socialist goal of reducing inequalities?
That is the central philosophical tension of modern Indian governance. It really is. Post-1991, the state shifted its method from direct control, the so-called license permit Raj, to regulation and facilitation.
So the ideal didn't just disappear.
Not at all. The preamble socialist ideal didn't vanish. Instead, its interpretation evolved. Today, it primarily mandates that the state ensure the benefits of economic growth are distributed equitably.
By focusing on opportunity and safety nets.
Exactly. Creating opportunity and maintaining a strong social safety net, like the National Food Security Act or robust public health care. The goal remains socioeconomic justice, even if the tools have changed from, say, nationalization to targeted welfare and regulation.
Moving to secular, also added by the 42nd Amendment, we hear a lot about Indian secularism being different from Western models. Can you articulate that difference in the context of the preamble's vision?
The core idea of Indian secularism is distinct. In many Western models, what's sometimes called negative secularism, the state maintains a strict separation from religion.
A wall between church and state.
Right, essentially prohibiting state support or interference. Indian secularism, often termed positive secularism, means the state treats all religions equally. Sarva Dharma Samabhava.
So it supports them all in a way.
The state supports, respects, and can provide aid to all religions equally, and crucially, it maintains the right to intervene in religious matters to abolish social evils, like untouchability or practices that undermine gender equality.
So if the constitutional commitment to religious freedom was already guaranteed in the Fundamental Rights Articles 25 to 28, why did the Constitution makers feel compelled to add secular to the preamble?
Well, it was an act of reinforcement and explicit declaration, largely influenced by the political climate of the 1970s, while Articles 25 to 30 already operationalized religious freedom.
Right, guaranteeing freedom of conscience, the right to practice and propagate religion, and so on.
The addition to the preamble served as a definitive philosophical statement that this commitment was part of the basic identity of the Republic. It acts as an absolute check against any future majoritarian government attempting to dismantle the multi-faith character of the Indian state.
Our fourth ideal is democratic. Beyond the obvious meaning of just elections, how does the preamble employ this term?
The preamble uses democratic in a far broader sense, embracing not just political democracy, but also social and economic democracy.
Okay, let's break that down. Political democracy first.
Political democracy, which is the system we often focus on, manifests through universal adult franchise. That's Article 326, periodic elections, the rule of law, an independent judiciary, and a representative parliamentary system where the executive is accountable to the legislature.
And the broader, less visible dimensions, social and economic democracy.
Social democracy dictates that all citizens must enjoy equal status and treatment, regardless of birth, caste, or social standing. It's seen as a necessary precondition for political democracy to function meaningfully.
And economic democracy.
That's tied closely to the socialist ideal. It aims at ensuring the equitable distribution of wealth, the abolition of gross economic inequalities, and securing distributive justice. Dr. B.R. Ambedkar famously warned that political democracy could not survive unless it was founded on social democracy.
So the preamble holds the state accountable for achieving all three.
It does. It's a tripartite vision of democracy.
Finally, we arrive at republic. This term is often confused with democratic, since most republics are democracies. What is the fundamental distinction the preamble emphasizes?
The functional distinction is the head of state. A republic contrasts directly with a monarchy. In India, the head of the state, the president, is elected, albeit indirectly, and serves for a fixed tenure.
So the political sovereignty rests with the people, not a hereditary ruler.
Exactly. In Britain, which is a democracy, the head of state is hereditary. That's the key difference.
So being a republic ensures that every public office is theoretically open to every citizen, regardless of their birth.
Precisely. The twin implications are, first, the fixed term and elected nature of the highest office, preventing the state from becoming a monarchy. And second, and more profoundly, the absence of any privileged class or hereditary ruler ensures that the dignity and equal political status guaranteed by the preamble are absolute.
With the nature of the state established, we move to the purpose. The four major objectives declared for the citizens: justice, liberty, equality, and fraternity. Let's start with justice, which is sought in three forms: social, economic, and political. This is the supreme objective.
Justice here is the ethical, moral, and conceptual spine of the entire document. It was drawn heavily from the principles of the Russian Revolution of 1917, reflecting the Constituent Assembly's desire to move beyond purely political freedom toward, material welfare.
Starting with social justice, how is that constitutionally secured?
Social justice requires the equal treatment of all citizens without distinction based on caste, color, race, religion, or sex. Its security is multi-layered.
How so?
It's directly enforceable through fundamental rights like Article 15, the prohibition of discrimination, and Article 17, the abolition of untouchability. However, its full realization also demands proactive state action under the DPSPs.
Like Article 38.
Yes, Article 38, which mandates the state to secure a social order for the promotion of the welfare of the people. It's about actively building a welfare state that counteracts historical discrimination.
Then there is economic justice, which concerns non-discrimination based on wealth.
Economic justice mandates the state to reduce deep-seated economic inequalities, ensuring that wealth concentration doesn't negate political or social freedom. While the Constitution doesn't enforce strict economic parity, it does mandate policies designed to reduce the gulf between the rich and the poor.
For instance.
The original impetus behind the abolition of zamindari and the implementation of land ceilings was a direct manifestation of this preamble goal.
And political justice.
This is secured through the equal participation of every citizen in the political sphere. So, equal political rights, equal access to all public and political offices, and an equal voice in the governance process.
The most explicit guarantor being Article 326.
Exactly, which guarantees elections based on universal adult suffrage, ensuring one person, one vote. Furthermore, the guarantee of access to public office via Article 16 reinforces this political equality.
And when we combine social justice and economic justice, we get the powerful concept of distributive justice. Why is this distinction so crucial for understanding the polity?
Distributive justice. It's the constitutional concept that justifies state intervention to ensure resources, opportunities, and the benefits of society are shared fairly across different groups. This is the conceptual bedrock for some of India's most important and often controversial policies.
You mean things like reservation policies?
Exactly. Reservation policies are designed to secure both social representation and economic opportunities for historically marginalized groups. Or think of a targeted welfare delivery under the National Food Security Act.
It's fundamentally an attempt to ensure a minimum level of socioeconomic justice.
Precisely. For the aspirant, understanding that policies related to land reform, labor laws, and welfare spending are all constitutional obligations rooted in distributive justice. It transforms a factual question into a conceptual one.
Moving to the second objective, liberty, specifically of thought, expression, belief, faith, and worship.
Liberty, as envisioned here, has a dual function. Negatively, it means the absence of arbitrary restraints on an individual's activities, freedom from unnecessary state interference.
And positively.
Positively, it means providing adequate opportunities for the full, complete development of the individual personality. I mean, without liberty of thought and expression, democracy becomes hollow.
These liberties are unique because, unlike some other preamble goals, they are immediately backed by justiciable rights.
Precisely. The specific liberties mentioned, thought and expression, guaranteed by Article 19, and belief, faith, and worship, guaranteed by Article 25, are enshrined in Part 3, the fundamental rights.
Which means you can go to court if they're infringed upon.
Yes, you have recourse to the courts. However, and this is important, they are not absolute. The Constitution permits the state to impose reasonable restrictions on these freedoms on grounds like public order, security of the state, or morality.
So the preamble lists the promise.
And the fundamental rights deliver the enforceable mechanism subject to necessary limitations.
The third objective is equality, covering status and opportunity. What does status and opportunity mean in the constitutional framework?
Well, equality mandates the absence of special privileges for any section of society, and the provision of adequate, non-discriminatory opportunities for all. This manifests as three types of equality that the Constitution strives to secure.
Let's elaborate on civic equality.
Civic equality ensures that all citizens are equal before the law, regardless of their social standing. It's secured by a block of fundamental rights. Article 14, equality before the law. Article 15, prohibition of discrimination. Article 17, abolition of untouchability, and Article 18, abolition of titles.
So these articles essentially dismantle structures of social hierarchy and privilege.
That's a great way to put it, yes.
Then there is political equality.
Political equality ensures equal access to political processes and offices. Key here are Article 326, which we mentioned, for universal adult suffrage, and Article 16, which is about equality of opportunity in matters of public employment.
This ensures that the state machinery is equally accessible to all citizens, fulfilling that republic ideal we talked about. And finally, economic equality, which, as we noted, is more of a guiding principle rather than a strict legal right.
It's the implicit economic mandate. While there is no fundamental right guaranteeing economic parity, the state's continuous efforts, such as the creation of constitutional mechanisms for the upliftment of economically weaker sections.
Like the EWS reservation under the 103rd Amendment.
Exactly. That demonstrates the state's ongoing attempt to fulfill the preamble's commitment to providing equality of opportunity, even if that means targeted intervention to correct existing material imbalances.
That brings us to fraternity. Arguably the most difficult objective to measure and secure, focused on promoting a feeling of brotherhood.
Fraternity is the ultimate cohesive force. Without a sense of brotherhood, the principles of justice, liberty, and equality cannot survive in a diverse, vast nation like India. It's rooted in two main components:
Which are?
assuring the dignity of the individual and assuring the unity and integrity of the nation.
The word integrity here is significant because it was another addition from the 42nd Amendment. Why was it necessary to add integrity if unity was already present?
That's a very sharp observation. The addition of integrity in 1976 aimed to underscore not just the psychological and cultural oneness of the nation, which is unity.
But also the territorial wholeness.
Yes, the absolute necessity of maintaining the territorial and operational wholeness of the Indian state, especially during a period of rising internal security concerns and regional fragmentation movements. It was a clear warning that any action threatening territorial integrity would be met with the full force of the state.
So how does the Constitution actually operationalize this feeling of fraternity and unity?
Through several mechanisms. Firstly, single citizenship. This is a direct contrast to federal systems like the U.S., where you have both state and national citizenship.
Single citizenship reinforces allegiance only to the Union.
It does. Secondly, the fundamental duties, specifically Article 51A, which requires citizens to uphold and protect the sovereignty, unity, and integrity of India, and to promote harmony and the spirit of common brotherhood.
So fraternity isn't just a state duty.
No, it's a constitutional duty imposed upon the citizen as well. It's the ethical quid pro quo for the rights the preamble guarantees.
We have dissected the text, but the true legal power of the preamble lies in its, well, tumultuous judicial history. Now we transition to the core legal controversy. Is the preamble a substantive part of the Constitution or merely a philosophical introduction?
This legal question is the bedrock of constitutional law analysis for this audience. If the preamble is a part of the Constitution, it means two things. First, it has legal enforceability as a guiding source of interpretation.
Okay, and second?
Second, it could theoretically be subject to Parliament's amending power under Article 368, subject to certain limits, of course. If it's not a part, then it's legally irrelevant. It serves only an illustrative purpose.
The first major answer to this came in 1960 with the landmark Bari Union case. What was the Supreme Court's definitive stand at that time?
In the Bari Union case of 1960, the court was asked whether Parliament could cede territory to Pakistan. And in analyzing the Constitution's structure, the court acknowledged the preamble's profound significance.
They praised it, didn't they?
Oh, yes. They called it the general purposes behind the several provisions and a key to the minds of the makers. It confirmed that the preamble is an indispensable aid in interpreting ambiguous articles.
But despite that high praise, the court reached a very specific and surprising legal conclusion.
It did. The court explicitly ruled that the preamble is not a part of the Constitution.
Why? What was the reasoning?
The reasoning was largely structural. Unlike the preamble of the U.S. Constitution, which was adopted separately, the Indian preamble was adopted by the Constituent Assembly after the rest of the Constitution had been approved.
I see.
So the court reasoned that since the preamble itself contains no substantive operative power, it doesn't grant or limit powers to the three branches of government, it could not be considered a structural part of the legal text, but rather a summary of the goals.
So for 13 years, the preamble was constitutionally powerful, but legally weak.
Precisely. And this created a serious vacuum in the interpretation of legislative power, which really set the stage for the dramatic reversal in 1973.
That dramatic reversal came with the behemoth of Indian legal history, the Kesavananda Bharati versus State of Kerala case in 1973. How did the Supreme Court manage to so decisively reverse its earlier stand?
The Kesavananda Bharati case established the most important principle in Indian constitutional jurisprudence. Regarding the preamble, the Supreme Court utilized historical context that was, overlooked in Bari.
Which was?
The court pointed out that the preamble was based on the objective resolution moved by Jawaharlal Nehru in the Constituent Assembly back in 1946. This resolution was the structural outline, the conceptual blueprint upon which the entire Constitution was drafted.
So the preamble wasn't just adopted after the text, it was the conceptual precursor to the text.
Exactly. Recognizing its origin in the objective resolution, the court ruled that the preamble is a part of the Constitution. Furthermore, it recognized that the preamble, like any other part of the Constitution, was enacted by the Constituent Assembly. This restored its legal status.
And this ruling became the foundation for the Basic Structure Doctrine. How did the preamble feed directly into limiting Parliament's amending power?
This is the preamble's greatest contribution. The court ruled that Parliament, under Article 368, has the power to amend the Constitution, but that power is not absolute.
Right.
It cannot be used to alter, damage, or destroy the basic structure or the fundamental identity of the Constitution. The court then looked directly to the preamble's ideals to define what constituted that basic structure.
And which ideals were identified?
Core principles like the sovereign democratic republican nature of the Indian polity, the secular and federal character of the Constitution, the mandate of justice, and the fundamental freedoms guaranteed to the individual. All of these were identified as components of the basic structure.
So the preamble transitioned from being a mere summary to the unamendable source of the constitutional identity.
That's a perfect way to describe it.
This principle was tested again when Parliament tried to assert legislative supremacy over the judiciary and individual rights, particularly with the controversial 42nd Amendment, leading to the Minerva Mills case in 1980.
Yes, the Minerva Mills case provided crucial refinement regarding the preamble's operational goals. The 42nd Amendment had attempted to grant absolute precedence to the non-justiciable directive principles of state policy over the justiciable fundamental rights.
Specifically, Articles 14, 19, and 31.
Exactly. Articles on equality, freedom, and property.
This was essentially an attempt to prioritize the preamble's ideal of socialist justice over its ideals of liberty and civic equality.
That's the perfect summation. Parliament was arguing that to achieve the welfare goals, justice and socialism individual rights sometimes had to take a back seat. However, the Supreme Court, again invoking the Basic Structure Doctrine informed by the preamble, held that the constitutional vision is one of harmony.
The balance.
Yes. The court stated that the Constitution is founded on the bedrock of the balance between Part 3, the fundamental rights, and Part 4, the directive principles.
So the ruling was that destroying the balance destroys the basic structure itself.
Precisely. The court recognized that the objectives of the preamble require the state to pursue both individual freedom and social welfare. They are not mutually exclusive. If the state sacrifices individual freedom entirely to achieve welfare, it destroys the democratic and republic nature of the state.
So the preamble mandates a balanced path.
The golden path, as it's sometimes called. And the Minerva Mills judgment cemented the preamble's ideals as essential for maintaining this constitutional equilibrium.
This historical context is invaluable. Now let's pivot to the practical application. How does a student or a policy analyst use the preamble as a functional interpretive tool when facing an ambiguous law or analyzing a policy?
The preamble ceases to be an abstract historical text and becomes the ultimate philosophical guidepost. As recognized in Bari and cemented in Kesavananda, whenever a constitutional article or a legislative provision is ambiguous, the courts use the preamble as the objective resolution that defines the intent of the framers.
So it clarifies what the Constitution hopes to achieve.
Yes, it's the why behind the what.
Can you give us an example where the preamble is the guiding light for a policy?
Sure. Consider legislation concerning environmental protection or tribal rights. Such legislation might not always find direct, explicit sanction in a fundamental right. However, the constitutional commitment to assure the dignity of the individual and secure social justice
Is broad enough to be interpreted as mandating these things.
It's exactly broad enough to be interpreted as mandating a clean environment and equitable control over resources. The preamble guides the interpretation of the DPSPs, like Article 48A, and it broadens the scope of fundamental rights, like the right to life under Article 21, to include these welfare aspects.
Let's reiterate the ultimate check on legislative power provided by the preamble: the amending power and the basic structure.
This is the takeaway you absolutely must carry with you. The preamble is not just a part of the Constitution. It defines the non-negotiable essential core. Parliament can introduce new elements or modify existing structures, but it can never abrogate the core principles laid out in 1949.
Sovereignty, democratic form, republican structure.
Commitment to justice and secularism, all protected.
So if the Parliament attempted to abolish universal adult suffrage, for example, it would be instantly challenged.
It would be struck down immediately under the Basic Structure Doctrine. Universal adult suffrage is the operational definition of political justice and democracy concepts enshrined in the preamble. The attempt by the 42nd Amendment to grant unlimited amending power was neutralized because it inherently threatened to destroy the essential framework.
The principles the Constituent Assembly deemed foundational, which are all summarized in that first paragraph.
That's right.
Let's focus this linkage specifically to exam-style questions. When tackling a mains question on the effective implementation of a complex social scheme, say the National Food Security Act, why is the preamble the highest authority to reference?
Because the NFSA is not just an administrative scheme, it is a manifestation of the state attempting to fulfill its obligation under the preamble's commitment to securing social and economic justice.
So to critique its effectiveness, you have to establish the constitutional mandate first.
Yes. You would argue that its success or failure reflects the Indian state's ability to achieve the distributive justice promised by the founders. Merely citing a DPSP like Article 38 is insufficient. Referencing the preamble's solemn resolution to secure justice provides the conceptual high ground and demonstrates a comprehensive understanding of the polity.
Similarly, when discussing internal security issues such as left-wing extremism, which is often rooted in agrarian distress and land alienation, how do you connect that to the preamble?
Well, when policy implementation fails to address issues like non-implementation of land reforms or the failure to secure tribal rights, which fall squarely under the umbrella of economic justice and equality, it leads to deep-seated alienation.
And this alienation ultimately threatens.
It threatens the preamble's final objective, fraternity and the unity and integrity of the nation. The preamble, therefore, provides a diagnostic framework. When state policy falls short of the ideals of justice and equality, the resulting unrest is a direct constitutional failure to uphold the vision of 1949.
So the preamble serves as the highest benchmark against which the performance of the Indian state is measured.
That's the key application.
That brings our deep dive into the preamble of the Indian Constitution to a close. This has been a necessary word-by-word examination of the constitutional soul of India, moving from philosophical intent to enforceable judicial doctrine.
We have established that the preamble is the declaration of India's identity: sovereign, socialist, secular, democratic republic, and the promise it makes to its citizens: justice, liberty, equality, and fraternity.
And its elevated status, cemented by the Kesavananda judgment, grants it immense legal and philosophical weight, safeguarding the entire constitutional vision from being dismantled by temporary legislative majorities.
That's right.
We sincerely hope this robust conceptual foundation allows you to structure arguments and interpret complex policy challenges with greater clarity, depth, and confidence.
Thank you so much for participating in this incredibly detailed deep dive. We remain absolutely committed to providing content at this level of intensity and detail.
Before you click away, a quick notification about resources. We have free notes and practice previous year questions (PYQs) related to these foundational constitutional concepts available right now on our Telegram channel. They are there to help you immediately apply this conceptual knowledge.
Furthermore, for those aiming for the highest level of mastery, our premium notes, which include extra PYQs and detailed model mains answers for complex questions requiring the mastery of concepts like the preamble ideals, are available on our Discord channel.
And that's exclusively for our Legend YouTube members, so do join there. Your support is invaluable for the work we do.
It truly is.
And as always, please like this video, share your valuable comment about what core insights stood out to you in this deep dive, and if you are capable, please subscribe and join our paid membership to support the creation of future in-depth content.
Now here's a final provocative thought for you to carry forward. Building on the structural tensions we discussed between the preamble's goals and the state's functional ability.
We know the preamble mandates the securing of equality of status and of opportunity and social and economic justice. If we accept the premise of the Minerva Mills ruling, that the constitutional mandate requires a golden path of harmony between the non-justiciable welfare principles, the DPSPs, and the justiciable fundamental rights. What specific, non-legislative institutional reforms, beyond simple wealth redistribution, would best bridge the gap between the preamble's promise of equality of status and the stark, lived reality of inequality and multi-generational poverty, which continues to challenge the effectiveness of democratic governance itself?
This disparity constantly tests the fundamental vision adopted on November 26, 1949.
Think about that structural challenge, how to institutionalize the harmony between the ideal and the implementation as you prepare for your next big challenge. We will see you next time for another deep dive.